Can councils disregard or ignore medical evidence or evidence you get from another professional? Now, the reason I'm doing a video about this is I was on Facebook the other day and a post comes up in my feed which is from one of the groups I'm in. I'm not going to say which one it is because they seem to be able to start an argument in an empty room sometimes, but basically it really annoys me a lot of the time. I have to say, I don't quite know I'm still in it, but basically you get questions that are put in by people who've got very difficult situations, and you either get just very kind of dubious legal advice that comes back, or you just get this really negative sort of, oh, you know, you should be, you know, happy with what you got, you know, you're lucky or whatever. And both of them, you know, aren't helpful. But the question that I saw on this particular day was a lady who had a kid. She was in accommodation which was really badly affected by damp and mould. She had mushrooms growing up on her furniture and stuff. She's having to throw things out. And her doctor was basically saying to her that this is no place for her to be raising a kid. It's not good for their health. And the response that she got was, you know, well, you know, everyone's got damp and mould, it's, you know, really bad. And the key thing which I'm going to do a video about is someone said, you know, councils don't have to listen to doctors' letters. And I was like, well, they do. And I was just in the middle of kind of writing the bit of case law which kind of refers specifically to this situation. And she deleted the question, and I think that's just because the degree of negativity she was getting, which I was sad. So I thought, you know what, I'm going to do a bit of a video, and I'm not going to just talk about damp and mould and GP letters. I'm going to go a little bit further. I'm going to go through a kind of a selection of cases which just kind of highlight different nuances to how council should deal with this stuff. If you're interested about finding out more about the law, there's some really good resources. I've talked about them before, but I'll mention them again. So you've got the Housing Law Casebook, which is basically, I don't know, thousands of cases, thousands of case summaries of different kind of legal principles, and for me that's a really good way for me to learn. You know, I read how it actually works out in practice. That helps me get a grip of what the actual the principle is. And really good textbook, Housing Allocations and Homelessness. Jan Luber, he's just retired actually, but really good, and he's really good in that textbook at just explaining how it is the law can help the person, help the homeless person, which is refreshing. There are some other good textbooks out there. I'm told that Diane Astin does a really good book, and there's some free resources as well, because those books ain't cheap unless you get an old version, and then you have to worry about whether it's still in, you know, kind of still relevant. There's some free resources as well. If you haven't checked out and subscribed to nearlylegal.co.uk, so Giles Peaker, probably the most, you know, kind of well-respected housing solicitor in the country. You know, I'm not an expert, but I'd say he probably is. He does some really, you know, and has done for years. He's done such good explorations and explanations of different cases. So I remember when I kind of first was confronted by issues around housing law, I googled it and I came up with this blog. And even back then, this is like 12 years ago, he just arranged cases into a really kind of easy to find archive. So if you want to find out cases about vulnerability, for example, you'll be able to kind of search for it and find stuff on that. And he goes into a good degree of detail, but he makes it as easy as it possibly can be. And he's not afraid of kind of criticising councils heavily on it, so which is quite nice as well. So he kind of knows that you're not going insane. So there's that blog, as I say, you can get a newsletter on it. If you follow him on LinkedIn as well, or I think he's on Twitter, you'll get kind of an update about recent cases as well. So well worth checking out. There's a website called bailey.org. or bailey.org.uk. I'll put it up on the screen. It's got a lot of transcripts, so when these judgments happen, they actually kind of, you know, can be quite long, you know, accounts, essays or whatever almost, about what the law actually is. You won't find every case on there, particularly older cases don't tend to be on there, but you will find a lot of newer cases and the important cases, and it's just a really good way if you really want to dig down deep into what different principles mean. That's just a really good way to do it, and I've kind of done that before about certain issues like vulnerability or whatever. You know, you go in the HOTAC case or something like that, and you actually start quoting directly from that transcript, and it holds a lot of weight. It's, you know, that was a Supreme Court case. It's kind of what the law is now. So there's that. And finally, I'd say there's the LGO website, or Local Government and Social Care Ombudsman as it is now. It's still, the website's still lgo.org.uk. Again, this is one of my first kind of resources I found to actually understanding what the law said. And the most helpful section is the kind of decision section. So when they investigate a complaint, they will issue a decision, but they'll also explain why they made that decision. And very helpfully, they start by saying what the law is. And it's not just housing law, it'll be how it interacts with social care law or Equality Act law and stuff like that. So I just used to read them. I just read them every week. I still get a newsletter every Thursday lunchtime where you've got the most recent cases. But you can search for councils, you can search for kind of, you know, various decisions at different points. And it's for laymen. It's, you know, it's kind of written in a way which is reasonably accessible. Yeah, they do use a bit of jargon, but they do their best to try and explain that as well. So yeah, check that out as well. So anyway, let's get to some actual kind of bits of law. So the first case I'm going to talk about, it refers specifically to this question I saw in the Facebook group, and it relates to this case RV Medina XPD. And just to make the point, I don't even know what those abbreviations mean. I know that R stands for Regina, which is the Queen, but I don't quite know why certain cases will be like Samuels v Birmingham and other cases will be RV whatever. So I don't know what it is, but I don't need to know, it's all good. Medina's on the Isle of Wight, or it's part of the Isle of Wight anyway. And this lady was, for reasons I don't know, because I'm not able to see the full transcript, she was living in a beach chalet, which was badly affected by mould and damp. And her doctor had written a letter basically saying, this is not appropriate accommodation for your young baby, it's causing health issues. So she approached Medina Council and they basically said, what are you complaining about? It's 4 walls and a roof, you know, there's nothing we have to do about it. It went to court and basically the judge said that, yeah, there were 4 walls and a roof, but because the doctor had kind of said that it was not suitable for a young baby, it was therefore not reasonable to expect Miss D to stay there, and therefore she was homeless, therefore she was in priority need as well because she had a dependent child. So I'd hope that she then got housed suitably. So that's the Medina case. That's the one, as I say, I was typing furiously before the lady deleted the question. And so you see a lot of that, you know. So a real interesting question around Awabi Shack is, did anyone actually notice that that family was probably legally homeless? You know, I haven't read the coroner's report, but someone did tell me, somebody who I trust did tell me that they didn't actually look into this kind of question of whether they were legally should at all, and therefore they should have, you know, they potentially should have been rehoused somewhere else. So it's an interesting kind of thought to kind of go down when you're dealing with this kind of widespread issue around damp and mould that we're seeing at the moment. And also on damp and mould, just to mention it, the Housing Ombudsman, which is different from the LGO, has kind of done a really good set of reports about that, so well worth checking out. So that's the Medina case. And I'll try and, as I say, go through these cases that kind of draw out something a little bit new from each case. So the next case I want to look at is Kelly v Westminster. And this is a case I use all the time in the training that we do because it's really good for priority need, particularly around single homeless people and vulnerability. And if you're interested, do check out the Eventbrite link on the description, because we do regular open online courses where I guess it's a mix of professionals and just interested members of the public come along. It's a day's course on Zoom, very reasonably priced, and we get uniformly good responses, good reactions to it. So yeah, Kelly v Westminster. This guy, single homeless guy, obviously in central London. This was 2008 case, and he had a kind of combination of issues. So he had like back pain, asthma, he was using crack cocaine, and he'd been in and out of prison. And when he was in prison, he kind of functioned pretty well. And then he was released from prison, he would basically just kind of effectively fall apart. That's probably not a very nice way of saying it. But, you know, he was struggling to even manage a benefit claim. That was kind of that level of kind of difficulty he was having. And in the course of the inquiries, the housing officer dealing with this case wrote to the prison officer, or probably more likely the prison officer voluntarily wrote to the housing officer, let's say it like that. And in that letter, the senior prison officer said he can manage okay in prison, but as soon as he comes out, he can't. Therefore, I think he's institutionalised. And essentially what the housing officer did was that's kind of rip it up and throw it in the bin and ignore it. But actually, the judge in the case said, hold on a minute, the senior prison officer is the one with the expertise and the qualifications to make that assessment. The housing officer, who often won't have any qualifications at all, is simply just not placed to dismiss that evidence without giving a very good reason for it. And so, as far as I understand, Kelly won the case. Mr. Kelly won the case. So that's Kelly v Westminster. The next one, as I say, we're going to kind of go through different nuances to this principle, was a case called IA v Westminster, or words to that effect. It was Mr. IA. It's anonymised, so it doesn't give his actual name. And he had, I think he'd come to the country having been tortured in his home country. And the case as a whole was really just about, can a council legitimately reach a same-day non-priority decision? You know, can they really make enough inquiries in that day to be satisfied that that person is not in priority need? And the answer was hell no. So this case actually was kind of specifically set apart to say everyone needs to listen to this case. This is now the kind of the benchmark of how this should all be done. And there's a lot of interesting stuff in the case. So I'm going to put a link to it in the description. But so it's worth looking at. It's also worth looking at Nearly Legal's kind of exploration of it as well, because it does a better job than I do around it. But basically, the principle of the case, and I'm going to read a few bits out of it just so I kind of do it justice. So the judge said, where mental health issues and issues arising from historic mistreatment of former asylum seekers is concerned, the housing authority should normally consult with the applicant's medical advisors, both present and past, and with the relevant mental health services, and will usually seek to obtain a further assessment and report from a psychiatrist. And Giles Peaker comments, the upshot of this case is that any such advice by the in-house medical advisor should be referred to the applicant's GP and or psychiatric advisor for a response. And again, that's kind of like, I've taken it slightly out of context, so there's a bit more to it, but effectively in that case Westminster had an in-house GP or something that was kind of providing medical advice. It wasn't Now Medical. I'll come back to them in a little bit. But what the case is basically saying is where you've got complicated health issues, particularly mental health issues, there's going to be a degree of toing and froing, you know. So you might get a psychiatric report from a psychiatrist who's assessed the person. That will then need to be sent to the in-house advisor, and their response will then need to be sent back to the psychiatrist to actually comment on, you know, why there's a discrepancy, if there is one. And often there will be, because a cynic would say that counsellors use these medical advisors to downplay evidence, and it's a key kind of feature is that these medical advisors never actually meet the applicant at all. They never often see the full medical records. They never speak to them on the phone and so on. So really, as we'll see a little bit later, those medical advisors or whatever aren't really worth a lot in, you know, in kind of the real world when it comes to decisions. But counsellors do routinely just rubber stamp what you know that medical advisor will say, and not give any reason for why they're preferring the medical advisor over the qualified, you know, consultant psychiatrist or whatever who's actually seen the patient recently and given a full assessment. So as I say, really interesting principle there. There is some kind of questions, you know, obviously this was about a former asylum seeker who'd been tortured, but I would say confidently that the same principles would apply to anyone who's got complicated, certainly mental health issues. I would also extend that to complicated physical health issues as well. You know, there should be that toing and froing. So it's not just a kind of one shot exercise, get a medical letter from a GP, get your medical advisor, make the decision. There should be that toing and froing to actually, you know, iron out why there are any discrepancies, if there are any. So yeah, really useful case. So the next case I want to look at is Perrott v Hackney, or XP Perrott or whatever. It involved Hackney, that's all I know. So as I say, I don't know what that stuff means. But basically in this case, this guy, Mr. Perrott, he had some kind of physical health issues to do with his digestive system, and I'm going to kind of again just lean very heavily on what Nearly Legal have said about this case, because it just kind of does a better job than I can in explaining it. Because what happened was he had an assessment done by his own doctor, who was called Dr. Shuey, or I think I'm saying that right, and then the Hackney sent his case off to Now Medical, and so this Dr. Giovanna Hornibrook gave this response back. And again, you have a situation where Hackney just basically preferred Now Medical's doctors over the treating professionals. I'm going to read a couple of bits out here because, as I said, it does a better job than I had. So Dr. Shuey, who is his own doctor, had both examined and interviewed him. The judge further found that the reviewing officer erred in law by failing to provide any explanation for giving equal weight to the evidence of Dr. Hornibrook and Dr. Shuey. So there should have been no comparison. Dr. Shuey was the one who had more qualifications, knew this patient, and also had kind of done the proper assessment, proper examination, whereas the Now Medical doctor had done none of those things. They probably just got some medical notes, not even probably full medical records from or through Hackney, and the housing officer proceeded to kind of treat them as if they were kind of the same weight, and they're just not. The judge then went on to say that the reviewing officer had failed to provide a rational explanation for departing from Dr. Shuey's conclusion that Mr. Perrott was significantly more vulnerable than ordinarily vulnerable if rendered homeless. He also found a failure by the review officer to engage with the reasons given by Mr. Perrott and his treating physicians for claiming vulnerability. So what we can see here, if we kind of just go big picture for a second without going into the nuts and bolts of it, is that his treating professionals and Mr. Perrott himself presented a number of kind of health issues or whatever, a number of details around vulnerability, and the council officers involved just simply failed to engage with them. And so going back to our original question, can councils dismiss GP's letters? They can't. They need to genuinely engage with all of the points raised, and they need to give, you know, kind of an assessment of how much weight that assessment has. So your own GP who knows you, or your own psychiatrist who knows you, is always going to hold more weight than a Now Medical doctor who's never heard of you before, basically. So that's kind of an important principle with this case. And the next case is Lambeth XP Carroll. So I think this was a guy, Mr. Carroll, and in this situation the case makes the point that where you raise, or where an applicant raises evidence of, you know, some sort of significance around their health issues, you know, so if they said, oh, you know, I've got a bit of tennis elbow, now that's not significant. But anything that is more significant essentially is going to require some kind of contact or some kind of inquiry being made to the treating professionals, because, you know, I've seen it many times myself where a council has before it information which show that clearly there's reason to believe that the person might be vulnerable, and yet they'll make the assessment of whether they actually are vulnerable and therefore in priority needs without any reference or any kind of inquiry being made to the professionals supporting that person, which, as I say, this case kind of suggests very strongly that that's simply not enough. And it's interesting, so you can't, legally you can't tell a council what inquiries it should make. That's for the council itself to decide. But you can attack a council if they haven't made obvious inquiries. You know, the wording of it is like, you know, if they haven't made inquiries that no reasonable local authority could fail to make, or something like that. So you can kind of attack it. So if you've got someone with complicated mental health issues and they've made no attempt whatsoever to actually talk to the mental health services, then immediately you can kind of attack it. And if we actually go back to that IA case, one of the findings of that case was that the kind of the council's decision was Wednesbury unreasonable, which essentially is, there was obviously a case called involving Wednesbury, but basically in that case the judge said that, you know, if it's so unreasonable that no reasonable officer acting reasonably could make it, then it's Wednesbury unreasonable. So that's not an uncommon thing actually within the sector. I've certainly seen many decisions where it's just nuts. You know, you've got housing officers saying insanely stupid things, but they get away with it because no one challenges it, because when you get confronted by their Section 184 negative decisions, you can kind of get a little bit dumbfounded by, you know, all the kind of sections and the jargon and stuff like that they'll refer to, but the actual essence of the letter is just nonsense. By the way, I've said it before, council officers aren't actually very knowledgeable about housing law. They just use template letters, so, you know, they can sound very fancy, you know, they're quoting kind of bits of HOTAC and other bits of the Supreme Court judgments, but the reality is, I would be surprised if most housing officers have ever even read the Homelessness Code of Guidance, which is the, you know, the kind of bog standard bit of guidance that you need to do actually do your job. Instead, they're told all sorts of nonsense by their bosses and kind of colleagues, and that kind of replicates and kind of perpetuates the sorts of stupid things they do. So if nothing else, just know that you can challenge things. And as I say, in this case, if you're raising significant issues around health, well-being or whatever, the council has to go and do some inquiries into it. And as we saw with the IA case, it's very difficult to actually reach a same-day decision that you're not in priority needs without kind of fairly dealing with the information you get back. And another case, kind of making the same sort of point but a slightly different nuance to it, is Newham XP Lumley. And this guy was about as vulnerable as you're going to find. This guy had all kinds of issues going on. And again, it was a situation where his treating professionals were weighed against Now Medical, and it just made the point that the actual qualification of the medical professional should also be taken into account. So where you've got a consultant psychiatrist making an assessment, and then a Now Medical doctor does, who they might have some psychiatric training of some sort, but they ain't a psychiatrist and they're certainly not a consultant. Obviously you go with the consultant psychiatrist, not the Now Medical doctor. And then similarly in the case of Geest, which we're going to talk more about in the series we're doing with Will Flack around this, but in this case it just makes the point that a more recent assessment should be preferred over an older assessment, because obviously medical issues change over time, and in this case there was a very recent, I think it was a consultant psychiatrist kind of report that kind of talked about Mr. Geest's situation, whereas an older report done by someone else who, you know, kind of wasn't as well qualified was then kind of used to counteract it. And this case just makes the point, it's going to be the more recent one which is going to be more useful. If you've got a report or an assessment done from 4 years ago, there's going to be limited use, particularly where you're talking about risk of attempting suicide or something like that. It's clear that that's not going to be a legitimate way of doing it. And then finally, just kind of talking about this case, Wandsworth v Allison, it just makes the point that the job of the medical advisor is supposed to be just to help the housing officer understand the conditions, the diagnoses, that sort of thing, rather than going anywhere near making an assessment of whether the medical advisor thinks that they're vulnerable. I know Now Medical have been criticised before in judgments where they've kind of tried to say, you know, we don't think this person is vulnerable, and the judge has said, hold on a minute, that's for the council to make that decision, and the council can't just rubber stamp Now Medical's opinion about vulnerability, because in one sense vulnerability is specifically a housing issue. Obviously it's a word which kind of has connotations within health, but when the housing officer is looking at vulnerability, that's a very specific criteria that they're looking through, and the doctor shouldn't have any kind of input into how it is then assessed. Their job is solely to say what the health condition is. They should be saying, if they were trying to be helpful, what is going to happen to that health condition if the person becomes homeless, which interestingly is something that Now Medical don't appear to do very well. And also you kind of got other things that I've seen. So I'm slagging off Now Medical quite a lot here. I've dealt with them, or dealt with cases that have involved their evidence a number of times, and the actual small print of the letter actually makes the point that they've not actually met the patient, they've not carried out an assessment, they're just going on what the council sent them, and often what the council sends them is garbage. So I had one case, for example, where this guy had tried to kill himself twice, 2 different occasions, both times gone into a psychiatric unit, having been through hospital first. And the Now Medical letter came back saying this guy doesn't have a severe and enduring mental health issue, and I'm like, well, what do you have to do to have a severe mental health issue? If you've just, you know, come very close to killing yourself twice, how is it you can kind of come back? How can a doctor come back and say, oh, you know, it's not severe? I mean, it's just nuts, but it's what we're up against if you're actually trying to get people housed. So keep an eye out for that sort of stuff. I'm going to put a description of all this stuff into the comments, just so if you want to find out more about individual cases. And again, if you've got questions about it, do put them into the comments section. We've got a weekly live stream at 7:30 every Thursday. You don't have to watch it live, you can watch the recording, but we will anonymously take those questions through and just kind of try and hash them out a little bit and try and give a bit more detail that we can just in writing. So as I say, it's kind of often when you're asking questions, you won't be the only one thinking it. It's helpful for other people as well, so it's just a good way to get information out there. So yeah, and if you got this far, if you subscribe to the channel, you get notifications when we're putting new videos up there, so that might be useful for you. And if you want to get this stuff shared around a little bit, which I'm hoping it's been useful, do like it and stuff, because it just bumps it up the algorithm. But yeah, cool. As I say, hopefully this has been helpful. If nothing else, don't kind of give up if a council tells you you're not in priority need or you're not homeless or whatever. Just, you know, go through the process, challenge things, get as much medical evidence as you can from your people, and that is probably going to be enough to legitimately win the day. But you might still have to argue with them and kind of make the point to them.